Now that we have explored agency, the next logical step is to examine partnership law, as partnership law is essentially an enhanced form of agency. Much the same as agency, when confronted with a fact pattern, the first question to ask is, what is the relationship? And in this context, that means, does a partnership exist? Remember that we're coming from the context of when is someone responsible for the actions of another person. Again, just as in the agency context, to determine the answer to this question, we must look at the definition of partnership. And this is found in the Uniform Partnership Act. We'll be using 1997 as it's the most recent one, 202A, that states, except as otherwise provided in subsection B, the association of two or more persons to carry on as co-owners a business for profit forms a partnership whether or not the persons intend to form a partnership. So we'll see that the germane parts of this definition have been underlined, and we will look at them in detail. So we'll start with two or more persons. Essentially, we need two or more persons to be involved in a partnership because if we have less than two persons, we will have a sole proprietorship. So we need two or more persons in order to create the partnership. A bigger question is, who is a person? Obviously, individuals such as you and I are persons. But one of the things that may not be immediately apparent is that a corporation is a person and therefore can be a partner in a partnership, as can various forms of other entities who are separate and distinct entities. Another part of the definition deals with carrying on a business as co-owners. When we look at this part of the definition, the questions that you will want to ask is, how formal does this business need to be, and how formal does the co-ownership need to be? When we look at the cases that we examine in this part of the course, you will see that the answer to both of these is that formality doesn't necessarily rule the day, it's the substance. Were they in this business together? And we'll look at a little bit more of the definition shortly. Now, we also see that in the definition it's stated that whether or not persons intend to form a partnership, if the substance of the definition is met, the partnership is created. So we see that intent is not required, give or take. What intent do we require? We don't require intent that they form a partnership, just like we didn't require intent that an agency relationship is formed. There is a certain amount of consent or intent that needs to be had here, though, because the people have to be in a business together. And obviously, it would be very difficult to have that without intending to be working together in a business. So when we look at the level of intent that's required, the intent is not to be in the partnership, but whether or not they are in business. And we see, except as otherwise provided. Well, 202B deals with an association formed under a statute other than this UPA. A predecessor statute or comparable statute of another jurisdiction is not a partnership under the UPA. There are rules that are in 202C that are very helpful in determining whether a partnership is formed. And essentially, I have outlined here that they deal with property ownership, sharing of gross returns, and sharing of profits. If you look at 202C1, we see that property ownership, whether it's joint tenancy, tenancy in common, tenancy by the entireties, etc., ownership does not itself establish a partnership, even if profits are shared by the use of the property between the co-owners. Number 2, the sharing of gross returns does not by itself establish a partnership, even if the persons sharing them have a joint or common right or interest in property from which the returns are derived. And 3, it says that sharing of profits is a presumption that creates partnership. A person who receives a share of the profits of a business is presumed to be a partner, unless the profits were received in payment. Now, there are, I believe, 6 different types of payments that are outlined. But essentially, these are types of payments where It's not uncommon to be tied to the amount of profits generated, such as by debt, debt by installment or otherwise, services of an independent contractor, or wages or compensation to an employee, rent, annuities, interest or other charge on a loan, or for the sale of goodwill or business by installment or otherwise. How do we distinguish between agency and partnership? Because there is some overlap. A lot of agency concepts inform in partnership law. Well, the distinction you really have to start with is that agency, we see a person acting on behalf of someone, so there is a clear subordinate. When we're dealing with partnership, we see two persons or more carrying on together, so there is more of not necessarily an equality, because you can have partners that have like a 90-10 split, so that's not very equal, but that they are working together to do some sort of venture.